California continues to be one of the most active states when it comes to employment law, and the key labor law changes that are effective for 2026 affect wages, pay equity, leave rights, tax changes, AI use in HR, and record keeping. This video will help you understand what has changed, what's coming, and where employers need to adjust policies or practices. These resources are excellent starting points for general HR questions, compliance guidance, and employee rights. They don't replace legal advice, but they're reliable, up-to-date, and accessible for both employers and employees in Los Angeles and Ventura counties. For all employers in California, regardless of size, the statewide minimum wage is $16.90 per hour, effective January 1st, 2026. When the minimum hourly wage increases, so does the minimum salary requirements because it is set at twice the hourly minimum wage. That is why the minimum salary threshold increased to $70,304 per year as of 1/1/26. Certain industries have higher required minimum wages. Fast food chains are subject to a $20 per hour minimum wage. Healthcare workers fall into a range from $18.63 up to $24 per hour, depending on the facility type. And Los Angeles hotel workers must be paid at least $22.50 per hour. It's important to remember that these higher industry-specific rates override the general state minimum wage where they apply. In addition to the state minimum wage, there are now more than 40 local minimum wage ordinances throughout California. These local laws can include higher minimum wages, paid sick leave requirements, predictive scheduling rules, and flex time obligations. An important compliance point is that the applicable local minimum wage is based on where the employee is physically working, not where the employer is located. That includes remote employees working from home, employees traveling into different cities, client sites, or conferences. Most local wage increases take effect on January 1st. For example, West Hollywood is at $20.25, Mountain View at $19.70, Sunnyvale at $19.50, and Richmond at $19.18. Employers need systems in place to track employee work locations to ensure the correct local rate is being paid. SB 642 strengthens California Equal Pay Act. Employers are prohibited from paying an employee less than another employee of a different sex, race, or ethnicity for substantially similar work. There are still limited exceptions such as seniority systems, merit systems, production-based pay, or a bona fide factor other than protected characteristics. However, this amendment expands the definition of wages to include additional benefits, not just base pay. The statute of limitations has been extended to 3 years, and employees can recover up to 6 years of damages for continuing violations. Because of this extended exposure, employers should retain payroll records and documentation supporting wage decisions for at least 6 years. California's pay transparency requirements continue to expand. Employers must provide a pay scale to current employees for their position or to applicants for the position they applied for upon request. For employers with 15 or more employees, pay scales must be included directly in job postings. And under the SB 642 amendment, a pay scale is defined as an estimate of the expected wage range the employer reasonably and in good faith expects to pay upon hire. Importantly, this refers only to the starting salary range, not the entire possible range over the life of the position. Employers should review job postings to ensure compliance and then confirm that posted ranges align with actual hiring practices. For tax years 2025 through 2028, eligible workers may deduct qualified overtime income up to $12,500 for single filers or $25,000 for married filing jointly. The deduction phases out at $150,000 for single filers and $300,000 for joint filers. Only the premium portion of overtime qualifies, and only weekly overtime under the federal definition applies. California daily overtime and seventh consecutive day overtime do not qualify. This means employers need to be able to clearly identify and track weekly overtime premiums in their payroll systems. Here's an example on how that would work for an employee in California. Andrew works overtime in 2025 for a total overtime premium of $5,000. However, only $2,000 of overtime are for hours worked more than 40 hours a week. So in that case, only $2,000 in overtime premium would qualify toward the income tax deduction. There's also a new federal tax deduction for qualifying tip income effective for tax years 2025 through 2028. Eligible workers may deduct up to $12,500 for single filers or $25,000 for married filing jointly with the same income phase-outs as the overtime deduction. This applies to certain occupations identified by the IRS that customarily and regularly receive tips on or before December 31st, 2024. Employees can rely on reported tip income shown on their Form W-2, while self-employed individuals may qualify if they maintain adequate records, such as daily tip logs. Employers should expect employee questions about this change, but should avoid providing individual tax advice. So for instance, Anne is a restaurant server with a Form W-2 from her employer who reports in Box 7 $18,000 of Social Security tips. Anne did not have or report any additional tips on Form 4137. And Anne may use $18,000 in determining the amount of her qualifying tips for tax year 2025. The no tax on tips also applies to self-employed people who are in one of the qualifying occupations. So for instance, Doug is a self-employed travel guide who operates as a sole proprietor. In 2025, Doug received $7,000 in tips from customers paid through a third-party settlement organization, TPSO, which issues a Form 1099-K showing $55,000 of total payments, but the form does not separately identify the tips. However, Doug keeps a log of each tour that shows the date, customer, and tip amount received. Because Doug has daily tip logs substantiating the $7,000 tip amount, he may use the $7,000 tip amount in determining qualifying tips for tax year 2025. AB 2499 significantly expands protections for crime victims. The definition of victim now includes family members, and qualifying crimes include domestic violence, sexual assault, stalking, and other violent acts. Employees may take up to 12 weeks of job-protected leave if they or their family members are victims. The leave itself is unpaid, but employees may use accrued PTO, vacation, or sick leave. There's also new notice requirements. Employers must provide notice of these rights upon hire, annually, and upon request. If an employee discloses that they or a family member is a victim, the employer must provide the notice at that time as well. Effective January 1st, 2026, AB 692 restricts stay or pay contracts. Employers are generally prohibited from requiring employees to repay hiring or retention bonuses if the employment relationship ends. This also applies to tuition payments if the employee leaves before the stated time period. One potential alternative for the employer is to restructure bonuses to be paid at the end of a defined period rather than upfront. Employers should review offer letters, bonus agreements, and tuition reimbursement policies to ensure compliance. SB 294 introduces new requirements related to emergency contact information. Employers must provide employees with an opportunity to identify an emergency contact if they are arrested or detained during work time. These requirements must be implemented by March 30th, 2026, and the information must also be provided to new hires and annually to existing employees. Penalties for non-compliance can be up to $10,000 per employee, making this an area where employers should act promptly to update onboarding and annual notice processes. Beginning October 1st, 2025, new regulations apply to automated decision-making systems, or ADS. These include tools that use artificial intelligence, machine learning, statistics, or other data processing techniques to make employment-related decisions. The rules apply when the ADS is used for personnel decisions, such as screening job applicants, and they also apply to outsourced software and third-party tools. Employers using AI-driven HR tools should ensure they have an artificial intelligence policy and understand how these systems are being used in hiring or employment decisions. Finally, SB 513 expands employer obligations related to personnel records. Employers must provide current and former employees or their representatives copies of personnel files, including performance records and grievance documents, within 30 days of a request. Failure to comply can result in a $750 penalty plus attorney's fees and costs. And effective January 1st, 2026, these records must also include education and training records. This makes it critical for employers to maintain organized, complete personnel files and have a clear process for responding to record requests on time. There are several emerging regulations in California to be aware of. First is SB 7, No Robo-Bosses Act. I just talked about the ADS regulations that are effective 10/1/25, but SB 7 goes further and remains highly relevant because it was vetoed in its original form, but continues to drive regulatory enforcement and reintroduction efforts. SB 7 would require advance and post-use notice to workers when AI ADS is used in employment decisions, would prohibit sole reliance on ADS for discipline, termination, or deactivation, would require human review of AI-driven decisions, and would impose civil penalties for violations. Many employers believe they're done once they comply with current ADS regulations, but SB 7 would introduce continued legislative pressure on AI in HR and likely future compliance expansion. Although not fully implemented yet, SB 464 represents a major compliance risk area tied to pay equity enforcement. SB 464 would require employers to store pay equity demographic data separately from personnel files. It would create civil penalties for failure to submit pay data reports to the Civil Rights Department and signals increased enforcement focus, not just reporting. AB 1331 reflects growing scrutiny of employee monitoring, productivity tracking, and remote work surveillance tools. The key concepts under considerations are limits on video, audio, location, pace, and electronic monitoring, would prohibit surveillance during off-duty hours, prohibits monitoring in private spaces, bathrooms, break rooms, lactation rooms, and would restrict monitoring of employee residences and personal vehicles. SB 590 continues to signal expansion of paid family leave eligibility beyond traditional family members and would allow PFL benefits to care for a designated person with family-like relationship. California employment law continues to evolve rapidly, and 2026 is no exception. We've covered significant changes affecting wages, pay equity, leave rights, record-keeping, tax-related questions, and the growing use of technology and AI in the workplace. For employers, compliance in 2026 is not just about knowing the law. It's about operational readiness. That means making sure your payroll systems can handle multiple wage rates, your job postings and pay practices align with expanded transparency and equal pay rules. Your policies reflect new leave and notice requirements, and your record-keeping practices can support longer look-back periods and faster response timelines. It's also important to recognize the direction California is heading. Pending legislation around AI, workplace surveillance, pay data reporting, and expanded leave rights signals increased scrutiny and enforcement. Even where laws are not fully implemented yet, employers should be evaluating current practices now so that they're not caught off guard later. The best next steps are to review policies and templates, audit wage and pay practices, confirm your notice and onboarding processes are up to date, and work closely with HR, payroll, IT, and legal advisors to address areas of higher risk. California compliance is never one and done. Staying proactive, documenting good faith efforts, and building flexibility into your systems will put you in the strongest position moving forward.